On the slopes of Diamond Head. This is Kapiolani Community College. Kulia Ikanu'u, strive for the highest.
Aloha, this is Ben Carroll. Welcome to the Legal Environment of Business, BLAW200. Well, last time we took a look at partnership, tied it together with a little bit of agency, and today we're going to move on to corporations, kind of the big boys and girls of business entities. But first, let's take a look at what we covered last time. So, what are the similarities between agency and partnership principles? In other words, how are agents and partners related? Well, you will recall that partners are in fact the agents of each other. So each partner is both a principal and an agent. So that means that all the duties and responsibilities that we talked about when we talked about agents apply to partners. So they owe each other the duty of loyalty, duty of carrying forth the business. They have the same sorts of responsibilities for what the other one does. So whereas we talked about in sole proprietorships, one of the problems being the unlimited personal liability, in actuality with a partner, it's even more so because you're not only liable for your own acts, but also for acts by your partner in advancing the partnership interest. So liability is increased even more. But again, the important point is that you are an agent of the other, so the knowledge that one partner has is imputed concerning partnership affairs to the other partner. Okay, why should partners put their agreement in writing? And what are some of the desirable provisions? Well, remember we talked about a partnership does not need to be in writing. It can simply be an oral agreement like many other contracts, unless there's something about it that requires writing. So you can have an oral partnership. Why would that be a problem perhaps? Well, if you don't have the provisions clearly expressed, we know that the Uniform Partnership Act is going to apply and it's going to assume things for you. So if you don't have clearly stated provisions, then the UPA, the Uniform Partnership Act, will make assumptions about what your relationship is. And for the most part, it's going to assume that everything is shared equally. Profit, management, control, etc. is shared equally. So certainly if you want something different, if one person has put in more capital contribution and is intended to take out differently, then you want that there. Now perhaps the most important thing is in a partnership we generally have equal management responsibilities. So just like we talked about, most appellate courts want to have an uneven number so they don't have a tie. We could have a problem with a dispute in a partnership if we have equal management responsibility. So certainly we need to make provisions for how to deal with any kind of disputes that arise so that the partnership can continue merrily on. So that's certainly an important provision. And of course we want provisions about what the capital contributions were, how we're going to divide profits, what kind of draw, in other words, what kind of money can you take out on an ongoing basis, and of course how to wrap it up if we need to dissolve. So those types of provisions, kind of common sense provisions in how the partnership will operate. Okay, what kind of types of decisions require unanimous approval by the partners, and what happens when the partners disagree? Okay, well, the type of decisions that are going to take unanimous approval, not simply majority of the partners, are going to be partnerships that affect the core of the partnership. So adding new partners, if there's no provision for that, could lead to dissolution. So there are the type of things that affect the partnership interest at its most basic would require unanimous approval. Now, as we just talked about, if you do have a dispute, you need some kind of mechanism for how that's resolved. And typical, that would be ADR, as we've discussed previously. So some way of a mechanism for making sure that you can quickly resolve any kind of management disputes so that the partnership can continue on with its business. How does a limited partnership limit the liability of its limited partners, and how can they lose that protection? Okay, remember we were talking about kind of a range of business entities, starting with kind of the big three, which is sole proprietorship, partnership, and then we'll be talking about corporation today. And within this realm between partnership and corporation, there's an array of new types of entities, much more recently developed than our proprietorship, partnership, and corporation. And these limited liability entities are all attempting to mix the benefits of partnership and particularly to get the limited liability of the corporation. So how do they do that? Well, remember the guiding principle for how to limit your liability is in fact to limit your control. So in a regular partnership, what we call a general partnership, both partners are general partners. In other words, they both have equal rights to control, etc. And a general partner has the same liability. Now, if you have a limited partnership, what you're doing is you are taking away day-to-day control from one of the partners, and you're making them more of an investor. In other words, they're starting to look more like the corporate side. So they invest, but they don't do the day-to-day control. And so that's the limited partner. Now, the general partner would continue to have day-to-day control and the liability, personal liability. So we've taken the liability away by taking the control away of the limited partner. Now, how could the limited partner lose that? Well, if the limited partner kind of gets out of their role and goes in and starts taking management responsibilities and involving themselves in the control of the partnership, then they are giving up that right, so to speak. So they're not acting like a limited partner, and they may not be treated as a limited partner if they move into doing what a general partner would do. Okay, what is a particular liability concern of professionals in a partnership, and how is that dealt with? Well, as we discussed, one of the main areas where we started to look at limiting liability was with professions, so attorneys, doctors, architects, etc., accountants. And the problem is that in a professional relationship, very often one of the partners is the only one dealing with a particular client. So although you could say that a patient is a patient of the doctor's partnership, in actuality, very frequently, that patient is simply dealing with a single doctor. So the other doctors, the other partners, may not know what's going on, and if there is professional negligence, in other words, if there's malpractice on the part of that professional, other partners may be unaware of that. But if they're in a regular partnership, they're going to be liable for that, as they are for all partnership obligations. So very early on, we had limited liability partnerships, and in those instances, what we were doing is attempting to shield a professional partner from the professional claims against one of the other partners. So obviously, you would remain liable yourself for your own negligence, but you would not be responsible for the professional negligence of one of the other partners. You're still on the hook for the general partner obligations, such as paying rent, the new copy machine, etc., but it was an attempt to isolate that professional negligence and limit it to the partner that's actually working with the client, patient, etc. Okay, well, we're going to get into corporations, and we'll deal with these a couple of sessions because it's a big issue. But we're going to start out with the basics of corporations. We'll review again the benefits and advantages, the drawbacks of the corporate form. We'll talk about some different types of corporations. We'll look at all the powers and liabilities, and we'll talk about the roles of the different groups that are involved in corporations. So, the corporation is a legal entity, and we refer to it as an artificial person. So what do we mean by that? It means that it has most of the legal rights of a person. So it has constitutional rights, freedom of speech, due process, etc. Does not have Fifth Amendment privileges, but it can start and operate a business, buy and sell property, borrow money, sue and be sued, and enter into business contracts. So what we've done is we've created a separate entity, separate from the owners. In fact, the word corporation actually comes from the same root word as corpus, meaning body. So we are creating a separate body that can do things just as if it were a person. So we will treat it in many regards as a person. And again, one of the important elements is this is separate from the owners. So even more clear in a corporation that we are separating ownership and control, because the owners are very obviously now different. We have a whole separate entity here, whereas with a proprietorship and a partnership, the entity is composed of the owners as opposed to being a separate being, an artificial person. Okay, now, as was the case with proprietorships and partnerships, these entities are established by state law. So there's not a national corporate law, although there's some model codes, but each of these is done by the state. So you will incorporate in a particular state. You will select the state in which you want to be formed. Now, there is a Model Business Corporation Act in Hawaii, and most states derive their corporate law from this Model Act. So quite similar in many regards, but there are differences, and you'll need to check. One of the decisions that you'll make is where you want to incorporate. And we'll talk about that in a minute. There are some states that are considered to be company or corporation friendly that do a lot of business with the larger corporations deciding to form in that particular state. Okay, now when you decide on your state, you have now identified yourself as being a corporation of that state, and within that state you're considered to be a domestic corporation. So if you're doing business in Hawaii and you have been formed in Hawaii, you are a domestic corporation with respect to Hawaii. Now, if you form in one state and operate in a different state, in the state that you are not incorporated in, you are considered to be a foreign corporation. So foreign means simply a different state. So if you're a California corporation come into Hawaii, then with respect to Hawaii, you are a foreign corporation. Back where you were formed in California, you're a domestic corporation as far as California is concerned. And finally, if you are formed or incorporated in a different country, a foreign country, you are considered to be an alien corporation. So in this instance, foreign country translates to alien corporation. Now, when we start doing business with Mars or wherever, we'll probably have to come up with intergalactic. But in any case, just recall that foreign means different state, not country. Different country is alien corporation. Now, of course, corporations doing business around the world can be referred to differently depending on what state is talking about them. So, as we discussed, in Hawaii, a Hawaii corporation is domestic, whereas when they operate outside, they could be a foreign corporation in California or an alien corporation if they're operating in another country. Okay, now, even though you form in one state, you generally have the ability to do most business in another state or another country. So the fact that you're incorporated in one place is how you're formed, but for the most part you can operate in other states and other countries as well. Now, the other state is going to have an interest in making sure that you are properly formed, and they're going to be more interested in what you're doing in their state. So remember in the past we've talked about jurisdiction, long-arm statute, etc. When someone comes into our state and does something, either tort or contractual breach, whatever. And so we want the ability to cause that person and or corporation to respond in damages or to respond to what they've done in our state. So how this generally happens is if a foreign or alien corporation comes into a state, they are required to register with the state and indicate who's responsible in the state for what we're doing here, who's the agent for service of process, how you can get hold of us if you need to hold us accountable. So we would register if we moved into a different state, register to do business, and we would indicate how it is that we can be served and contacted for what we're doing in that state. Okay, now, corporation, again, we've talked about them as being an artificial person, so they can participate in business enterprises pretty much like an individual. So you can have a partnership of corporations, you can have a joint venture where different corporations are involved. So in that sense, they can act like a person as an entity as well. Now, there are certain regulated, highly regulated types of businesses, and there are going to be additional laws that specify how they operate. So if we look at some special service type of corporations, such as banking, insurance companies, railroads, that sort of thing, then there are a lot of specific statutes that will tell them how to operate, in addition to simply the general corporation law that applies. Now, one of the things we talked about with corporation is corporation can outlast the owners. So recall when we're talking about a proprietorship or a partnership, if the owner dies, then the entity is over. But with a corporation, it doesn't matter what happens to the various owners because, again, the owners are separate. Corporation is its own entity, and so the ownership can change. People sell stock, people die, all sorts of things happen here. It does not necessarily affect the corporation. So the corporation can have what we call perpetual existence. In other words, it can last forever. And we know that there are corporations that have been around hundreds of years. And so that's, again, one of the benefits of being a corporation. Okay, now there are different personnel, different moving parts, so to speak, in the corporation. So we discussed this briefly, but we know that the owners themselves are the shareholders, and they become owners by owning shares, owning stock. Okay. They elect a board of directors, and the board of directors is the basic managing structure, and they make the big decisions, but they will hire officers, employees, to do the day-to-day work, so to do the basic management and control. So these are kind of the three basic groups. And a little later we'll talk about specifically about what the different rights and responsibilities are with respect to these different groups. Okay, so we talked about this very briefly, but when we first started talking about business entities, but let's go back and review the advantages of being a corporation. So we know the number one advantage is limited liability, and that's what everyone is trying to get, even in the hybrid limited liability entities, is they're trying to get this limited personal liability of the corporation. Now, again, some of the benefits that are different from proprietorships and partnerships are we can transfer the ownership rather easily. Since the ownership is divorced from the control, we can simply sell or give away or whatever our stock, and that changes the ownership very painlessly. Again, we talked about perpetual life. It's much easier to raise capital with a corporation. Generally, larger has its own, often has a track record, so it's much easier to raise capital for a corporation than it would be for most partnerships or proprietorships. And since control is separate from the owners, we can get very specialized management. So our management team, our officers and employees can be specialized. We're not dependent on what the skills, etc., of the owners are. So again, number of benefits. The key one, of course, was usually the limited liability, but as we've seen now, other entities also have limited liability, so that's not as critical as it once was. Okay. Now, the Disadvantages, downside, drawbacks, cons of being a corporation. Well, we've talked about the double taxation, and we'll talk a little bit more about that, but essentially what this means is since the corporation is an entity, it is taxed. So when the corporation makes a profit, those profits are taxed. Now, when they provide money to the shareholders through dividends, then the shareholders themselves, the same money is taxed again when it's received by the shareholders. So that's what we mean by double taxation, is the same profit comes through taxed at the corporate level, and then again when it's given to the shareholder is taxed. And that's again what we mean by double taxation. And that's generally considered to be the major disadvantage of the corporate form. And again, corporations do their best to limit this, but it's still there. And again, that's why the hybrid entities are trying to get the partnership type of taxation with the benefit of the corporation. Some other things are, as we've talked about, a lot more moving pieces with a corporation, so it's expensive to form, a lot more government regulation, and we'll be talking about that in a future session as well. And pretty much for most corporations, what you're doing is public. So if you're a publicly held corporation, we'll talk about in a minute, your books are fairly open to people. Again, there are privately held corporations, different types of corporations, but that's a drawback as well. And again, since you have these three different groups, shareholders, officers, and directors, there can be some internal problems since you have the very separation of this means there can also be some friction in those groups. But again, major drawback generally considered to be the double taxation and close following probably by government regulation. A lot of regulations about how to do business. Okay, so the different types of corporations. We talk about public corporation, but probably easier to think of this as being government corporations. Then we have a couple of varieties of private. And the one we're mainly concerned with when we talk about corporations, most of us are thinking of what we call publicly held. And these are companies that are on the stock market. We have some privately or closely held corporations, more like family businesses. Now, they can be quite large, but they have a very limited number. They're not publicly traded. And then we'll talk a little bit about some special forms, nonprofit or not-for-profit corporations, and very briefly, professional corporations. Okay, so the public corporation, or again, I prefer the term government or quasi-public. This is like a municipality or a Hawaii Housing Authority or Tennessee Valley Authority. And these are corporations that are set up, but they're government-owned, and they have a public purpose. So they are, you don't buy stock in them, your taxes pay for them. And again, they do government business, and although the term public is used for these, it's a little bit confusing because we talk about publicly held private corporations or normal corporations. So we just want to make sure you understand that the government is the one running these corporations. Okay. Now, in the private corporations, again, two different flavors of private corporations. The closely held or privately held corporation is not traded. So there are, again, some big companies that do this, but they're not the companies we tend to think of that we see on the stock market because these are not publicly traded. So when we think of corporation, again, we are thinking of a publicly held or publicly traded corporation. And these are the ones we see on the stock market. They have the call signs. So these are our familiar corporations. So you, as a public member of the public, you can you can become a shareholder or an owner in these publicly held or publicly traded corporations. Okay. Now again, the closed corporation is held by a small number of people, and generally they will have shareholder agreements that limit who the shares can be sold to. So they want to keep this a small group. They don't really want strangers involved in the management. So this is closely held, meaning that we keep it close to a certain number of people. And it looks, again, closer to a partnership. Again, small number of people, more informal than the publicly held corporations. Okay, so here you'll see just some familiar logos, and these are generally on the Fortune top 10 list of size of corporations. Some come and some go, but you can see these are all familiar, and these are our publicly held corporations. So these, you can be a shareholder or hold stock from these corporations. They are traded on the stock exchanges, and again, just normally when we think of corporations, this is the variety we're thinking of. Okay, now there are not nonprofit or not-for-profit corporations. Many people prefer the term not-for-profit because it indicates that, in fact, we intend not to make a profit, because unfortunately some of our other corporations are nonprofit, even though we would like them to be profit. So again, some people prefer to use the term not-for-profit, indicating that the intent, the purpose of this corporation is not profit-making. So we also refer to these frequently as 501c3, and what we're doing here is referring to the Internal Revenue Code, and that's the section that talks about tax exemption for this type of corporation, which generally is involved in educational, charitable, religious work. So it has a purpose, it has an aim or a goal other than making profit, and so the monies that come in are returned to the corporation. They do not go out to shareholders or owners. Now, if you're in the accounting area, you will find that we have considerably different accounting for not-for-profit, kind of obvious since we're not accounting for profits. So if you are doing the accounting, this is a very separate area, a different type of accounting. Just a quick note on these is, now these not-for-profits can sell things. So they can certainly sell T-shirts. If they're the Red Cross, they could sell first aid kits. They can sell things that have to do with their business, but they may end up in some accounting difficulties if they're selling something completely unrelated to their purpose. Why? Because then they would be competing with, in a sense, profit corporations, and if they're given this protection of tax exemption, the profit corporations are concerned if they're moving into businesses kind of unrelated to the purpose of the nonprofit. In other words, unrelated to the purpose for which they were given a tax exemption. Okay, and finally the professional corporation. Again, professional corporation has the same aim as the limited liability partnerships. In other words, the professions have this one-to-one relationship with clients and patients. Now, as a corporation, they are given protection because they are now, the corporation is separate from the owners. But whereas in a limited liability partnership, we were kind of increasing the protection for this professional liability for the partners, now with a corporation where it's a broader protection, we're kind of decreasing it. So in the professional corporation, we're saying you are protected from the entity liabilities. In other words, as we talked about before, the rent, the copy machine, the supplies, but just because you're a professional corporation does not shield you from your professional negligence. So in essence, the limited liability partnership and the professional corporation are looking for the exact same aim. In other words, they're seeking to protect you from the malpractice or professional negligence of one of your other members, but you are still on the hook for the corporate, professional corporation or limited liability partnership obligations with respect to the non-negligence area. So you cannot escape your professional negligence by forming a professional corporation, and that's the reason that was set up. Now, the professional corporation does refer to some ways of protecting yourself, insurance requirements. It talks about some of the professional aspects such as confidentiality, etc. Okay, now how do we form a corporation? As we said, it's more complicated to be a corporation than it is to set up a proprietorship. In many instances, as a proprietorship, you could simply set that up, very little formality, sometimes not even registering unless you had a trade name or something. So corporation is the state's much more interested in, for some of the reasons we've already talked about, is because you are now separating your liability. And just as the state wanted you to have limited liability in your name for these other entities, they're concerned that when you set this up, because it is a completely separate entity. So first thing probably you want to do is consult with appropriate experts, and most people will need to talk to either a lawyer, tax expert, or accountant to do this. Next issue is you're going to need to decide where to incorporate, because again, remember, this is a state law that sets you up. Now, you don't necessarily need to incorporate in the state where you're mainly going to do business. Okay, so you can have a separate location from your state of incorporation. Now, what's that about? Well, for average, if you were setting up your own corporation, you might very well choose to incorporate in the state you're in. But nowadays, when you're doing so much on the internet, not quite as important where your actual incorporation location is. Remember, I said most of the major corporations have picked a particular state that is friendly to corporations. In other words, perhaps easier reporting, good fees, and that sort of thing. And you wouldn't guess where it is. Small state, but not Hawaii. Okay, so it's Delaware, and Delaware has gotten a reputation over many years of being a state that is corporation-friendly, and so many of your larger corporations, probably the majority of the logos we just looked at, are going to be Delaware corporations. Now, that doesn't mean their main office is there. Their main office can be Los Angeles, New York, Dallas, wherever, but they are a Delaware corporation, and they incorporated in Delaware because of the benefits of doing that. Okay, once we decide where we're going to incorporate and where we're going to do business, we would get our major document, in other words, our articles of incorporation, prepared, and we would file it with the appropriate state office. And then finally, we'd need to have our first organizational meeting, and that's where we would adopt our bylaws, which are more detailed governing documents. We would elect our directors if we hadn't already done that in our incorporating, etc. So again, a little more involvement in putting together the corporation. Need to follow our state laws, make sure that we are forming this entity that will give us, in fact, the limited personal liability. Okay, so in most states, you are a corporation when your articles have been accepted by the Secretary of State or the appropriate state office. And if they're accepted, this means pretty much you are now legally a corporation. And we use the Latin term de jure, meaning by law you are now a corporation. So that's when your protection would begin. Okay, now if you have not done this quite right, in other words, there's something defective about your articles, you haven't followed one of the provisions in the Corporation Act in your state, but you're substantially in compliance and you've already started operating, maybe the technical problem may not destroy your corporation. You may be considered a de facto, in other words, a corporation in fact. So you're close enough, you're operating, and so the court may say you are in fact a corporation. You need to fix the problem, but you're going to be considered a corporation even now. Okay. But if you've completely missed the boat on this and you have a defective incorporation, you haven't even complied enough to bring yourself within the corporation, in fact, the de facto, then you're not a corporation at all, and so obviously you do not have those protections. You're not a separate entity at that point. Okay, and we have our old friend estoppel that comes in. So as we've seen in many other areas, if you lead somebody to believe that you're a corporation and they deal with you and then thereafter you try and give the defense, hey, we're not a corporation, if you have fooled a third party, it may be that you will be held to be a corporation for that purpose. Now, this doesn't make you a corporation for all purposes. In other words, if you're held to be a corporation by estoppel with respect to this particular transaction, that doesn't magically make you a corporation for future work or future purposes. That's just a holding of the court, an equitable holding with respect to this third party in this particular instance. Okay, now what do we have in our incorporation articles? Again, this should start to look familiar. This is the same sort of thing that we're going to see in our partnership agreement and some of the other agreements we've looked at. So we need to have the name and addresses of who the folks are, the incorporators, purpose of the corporation. Again, purpose now is done very broadly. Even if you specifically want to open up a pizza parlor, you will probably say a pizza parlor and any other activities that are legal, something like that. So you'll put a catch-all in there that will pretty much say whatever we do is fine. And we'll talk in a minute about why you want that very broad kind of catch-all statement in your purpose. Okay, now something we'll have to add that we didn't in our other entities is we're going to talk about the ownership. So we'll talk about stock. We'll talk about different classes or types of stock, and we'll mention this a little bit in our next session. Okay, we need to have the rights and privileges of the stockholders, and we may need to put the duration, although in general the duration often is expected to be perpetual. So again, same sorts of things we needed earlier, with the addition of we need to define how the stock, how the ownership operates, because again, we have separated our ownership from the entity itself. Okay, what are the corporate powers? Well, we talked about the corporation acts like a person. So they are limited, of course, by the Constitution, state statutes, and their own governing documents. But other than that, very broad powers set out in the Corporation Act. Now, the board resolution, what the board resolutions are, this is the day-to-day actions of the board of directors. They will pass a board resolution. Okay, now the express powers, these are going to be set out in the governing documents. So this, by express, we mean stated powers. And we also are going to have implied powers. So again, implied powers are not expressly stated in the governing documents, but they are implied. In other words, you can infer these from the powers that are expressed. So if we say the corporation can do X and a necessary prerequisite to that, or a necessary precondition is to do Y, then that's going to be implied, because we've said they're able to do this act. To do that, they would need to do this. Makes sense logically. They can do both. So a couple of examples are they can borrow and lend money, make charitable contributions, etc. So these may be set out probably as powers even in the state corporation code. Very often they're going to be in your articles of incorporation or your bylaws, but if not, the court will sensibly imply them if they are necessary to do the express powers. Okay, now an officer can bind the corporation. In other words, the officers are doing the day-to-day stuff. In the ordinary course of business, they can bind the corporation. And again, this makes sense because the officers and employees are, in that respect, agents of the corporation, so they can bind the corporation in these normal ways. However, they are not able to bind the corporation in major core kinds of changes. In other words, sale of major assets, trying to change the type of business, that sort of thing. So they're naturally limited to what you expect officers of a corporation could do. Okay, we have a little more Latin for you. Ultra vires doctrine. So ultra vires simply means beyond the power. So this is an instance where we're saying that the corporation or its directors, officers have gone beyond what the corporation is authorized to do. Remember, we said in the articles you would put a very broad definition of purposes. So you would try and prevent the possibility that you acted outside your powers. So for the most part, the corporation itself is not going to be held beyond its powers, although directors could do acts that are not part of what they're authorized to do. So we'll see ultravirus a little bit. Now, what happens if the corporation goes beyond its powers? Well, this is an instance where the shareholders can rise up and bring an action against the corporation or against its officers and directors. So either the shareholders or even the corporation itself could go after its own directors and officers if they've done something beyond their powers. And even the state, by virtue of it giving the certificate to the corporation, can go after the corporation and even move to dissolve it if it is acting outside the scope of its powers. So you can see ultravirus really involves kind of internal remedies for something going wrong in the corporation. So the shareholders of the corporation can kind of clean up its own act by going after the directors and officers that are doing something that they're not authorized to do. So this is an instance where the shareholders do get kind of actively involved in the corporation if there's something going wrong. So again, we look at ultravirus as being kind of an internal remedy, even though we did say that the state could come in. But for the most part, it's the internal shareholders going after officers and directors that are exceeding their authority. Okay, in another instance, we have the corporation is dealing with outsiders. So we kind of consider this remedy for external problems. We call that piercing the corporate veil. So corporate veil is kind of a word picture, veil or curtain. And what we're talking about is kind of the protection from personal liability. So the corporate veil we could think about as being the veil or the curtain around the individual shareholders, officers, and directors, protecting their personal assets. And when we talk about piercing it, we're talking about we're going to be able in certain instances to go through that protection and go after the personal assets of shareholders, officers, and directors. So that's what we mean by piercing the corporate veil, is we're piercing the corporate protection from personal liability. Now, when does this happen? It happens when it appears to the court that the corporation is either a sham or it's being used to hide behind. And that's the general reason that we would pierce that, is because it's kind of a misuse of the corporate structure. And so the court's saying, in fairness, we're not going to allow you to have that corporate protection if you're misusing it. What would be some of the instances? Well, this is where if you haven't properly formed your corporation, you may be at risk because you have not had that corporate protection attached, and so you may be at risk. More importantly is if the court feels you weren't really ever trying to be a corporation, you were simply trying to do your business as individuals and you wanted to have the protection, but you didn't really intend to operate as corporations are supposed to operate. Okay, so then if a third party is dealing with you, as is usual in the equity, we're going to protect that third party. Okay, so again, if it's a sham or if you are simply using the corporation to do your own thing, you commingle assets, in other words, as a separate entity. Again, the accounting for that is separate from the individual owners. But if you're mix and matching, if you're not acting like a corporation, then the court may not treat you as a corporation. So if you are not really intending to be a corporation, you're not acting as a corporation, then the court will not treat you as one, including the protection from personal liability. Okay, so again, we talked about the different corporate roles, so let's look at the corporate roles. And hopefully it's useful to you to look at a couple of different aspects so that we can distinguish it with what the shareholders are doing compared to what the officers do and what the directors do. So I find it useful to look at what's the main function of this particular group in the corporation, how did you get to be a shareholder or an officer, etc. What do you get to vote for? What kind of control do you have over the day-to-day stuff that the corporation does? what is your personal liability for the acts and debts of the corporation, and what do you get paid, if anything, as a member of that kind of role group. So looking at the different roles, when we look at these kind of factors, we'll have a better idea how these fit together. Okay, so just very briefly, the directors are elected by the shareholders, and they do the overall management. So they are making policy, they're making major decisions, that sort of thing. Now, officers, they're hired by the board of directors or appointed, and they're responsible for the day-to-day. So these are the managers, these are the operational folks that do the normal work of the corporation. And then finally, the shareholders, we know that they get to be shareholders because they buy or inherit or in some legal way get stock, and that makes them a shareholder or an owner of the corporation. Okay, so the board of directors, elected by shareholders. Now, their individual directors are not agents. The board can be an agent and bind. Now, the directors could also be a shareholder, officer, it can be a combination of these, and obviously their responsibilities, etc., they'd be wearing different hats, so they could be a number of these, and we would look at them in that role for particular transactions. Okay, now they oversee generally the corporation and protect the owner's interests, but they're not going to get involved in the day-to-day. So we actually, if the directors are getting involved in the day-to-day operational, we actually talk about that as being micromanaging. So we don't want to see them doing that little stuff. They are simply setting policy, and they're monitoring what the employees and the officers do. So they are overseeing but not actively involved in the day-to-day. Okay, so what are some of the major things that they're going to be doing? Well, they get to participate in the major decisions. They get to inspect records. Now, the compensation is going to be minimal, so they may get paid for meetings or kind of a stipend sort of thing, but generally this is not their main paid position. They're very often on other corporations or businesses, so this is not their main income for the most part. And they will be indemnified. So we've talked about indemnification before, but as their work as a director, if they're doing legally and within authorization, they would be protected, and the corporation would pay for their defense if they were sued, that sort of thing. And most of this is going to be covered, as is often the case with risk, with insurance. So we have errors and omissions insurance that would cover this. Okay, so what are their duties? Basically, they handle all management decisions, major corporate policy, such as the financial decisions. Are we going to have dividends or retained earnings? And another major responsibility of the directors is to hire and fire, essentially, the officers and the key employees. So they do, again, the broad brush policy decision making. Okay, now the officers, executives hired by the board of directors, and these are the employees. So even though we call them a CEO, they are in fact going to be an employee. So if we talk about the principal-agency relationship, essentially the employees are going to be agents of the corporation. So the corporation itself is the principal, and they're acting on behalf of the corporation. So again, corporation, again, seems to be a person in this regard. Okay, again, they can serve more than one role, and they have their regular fiduciary and loyalty duties just like agents and employees we've talked about in the past. So their employment relationships are going to be generally by employment contract, some quite lucrative. You've heard of the golden parachutes for termination, that sort of thing. But it is contractual, just like other employees. Okay. Now, both officers and directors are going to be fiduciaries, so they're going to have some duties to the corporation itself. And again, these are going to track the duties we looked at really for the most part with agents. So duty of care, making informed and reasonable decisions. And here it's important that we rely on good information, in other words, competent consultants and experts, and that we are responsible for reasonable supervision. Now, if the board of directors makes a decision outside authority or a bad decision, and you disagree with that as a director, you will be protected if you go on record as being opposed. So if you think something's going wrong, you would want to get into the minutes that you disagree with this to protect yourself later on if there's a problem. Okay, now we do have some protection called the business judgment rule. And essentially what this says is we're not going to second guess what happens with the directors or officers, because in 2020 hindsight it may look like could have been a better decision. But what we're actually going to do is apply a reasonability test, a business judgment, and say we're going to protect these decisions as long as they were reasonable, you were informed, and you made it in good faith in attempting to advance the interests of the corporation. So even if it was wrong, you're going to be protected from it if you fall within business judgment. Okay, duty of loyalty, again, sounds very much like when we're talking about our agency. You won't compete with it, conflict of interest, insider trading, and we'll talk about that next time, is something added to this. Okay, conflict of interest. Since it is a separate entity, you may have your own business interests. So this is a concern, conflict of interest, and you should not be voting if you're a director on something if you have a personal interest that would go one way or another. But what's interesting is that even though you should have been excused if you vote, but the directors vote as well, it's not going to void that particular decision just because you shouldn't have been involved. So if disinterested directors vote for it as well, then this decision would stand. Okay, now we get to the shareholders. And again, we know the shareholders are owners. So as a general rule, you have no rights to manage the day-to-day stuff. And again, you don't want those rights because that's what protects you from personal liability, is being divorced from that. So you do have the right to elect directors. And on occasion, you will have the right to vote on other major decisions. So at a shareholder meeting, there may be issues that come up where the corporation's very status is changing, so mergers and acquisitions we'll talk about in a little bit next time. Something else affecting your ownership rights, you may be able to vote on. If you're being taken over by another country, if they're doing some kind of adjustment of your ownership interest. But again, these are the big decisions. Very frequently, shareholders are not going to attend annual meetings, may not even send in their proxy to vote. As long as the dividends are coming, stocks going up, they're not going to have much, if any, interest necessarily in participating. Okay, so what are your powers? Again, you can approve all fundamental changes. So again, these are the big decisions that affect your ownership interest, such as amending the articles. As we talked about, mergers and acquisitions. And again, the one thing you can count on is you do have a right to elect and remove board of directors. What are your rights? You get to vote, inspect the records, transfer your shares, receive dividends if declared by the board. And in the instances we already talked about, you may be able to file suit for the corporation if there are ultravirus. Okay, what is your liability? Very little liability. If corporation fails, your loss should be restricted to what you put in. Some rare exceptions if you've gotten your stock in some kind of sweetheart deal, called watered down stock. But otherwise, most you can lose is going to be simply what you put into the corporation. Okay, well, that's kind of our quick little trip through corporation structure, kind of the basics of corporations, giving you a taste of the different groups. So there is a considerable amount of material, as always, on the website. So take a look at what's available there, give you a little more background, because this is can be a complicated area. And next time, we will be looking at mergers and acquisitions. We'll be looking at the financing of corporations. We'll be looking at securities regulation, and we'll look a little bit at corporate ethics and some concerns there. So this has been Carol saying aloha. See you next time.